There are still folks out. Thank you, Margaret. There are still folks lined up outside. I just have some housekeeping I want to go ahead and do because again, we're waiting for all of the jurors and defendants and witnesses and everybody else everywhere to get in and get ready. Um, First thing I need to do is the direct contempt hearing for Xavier Jones. Mr. Jones, deputies, y'all may bring him up to the podium. Did I get ahead of Piper? Oh, I gotta have him. If you'll just bring him up to the podium and then. Thanks, Deputy White. Okay. Placing you under oath, do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? All right, do you? You've nodded your head twice, but I need you to answer out loud for me.
I do.
Okay. Mr. Jones, you are Xavius Rashard with an A, Rashard Jones. Is that correct?
Right.
Xavius, Zavious? Yes?
Yes.
Okay. Mr. Jones, you and I have already met because I don't know if you've noticed, but today in this courthouse, we have a lot going on. We have 100+ jurors here for Superior Court, which this is not Superior Court. We have dozens of jurors here for State Court. We have court going on every floor. We've got 30 people outside the courthouse doors just trying to get in. And frankly, I needed today to go very smoothly. I needed everybody to do what they were supposed to do, when they're supposed to do it, the way they're supposed to do it, so that we can get started. And you are the one who has made that not happen. And so that's why we're having what's called a direct criminal contempt hearing. Because I got a call that said, I have a juror who smells so badly of burnt marijuana that we can't breathe down in the jury room. So I said, well, there's only one way to know for sure. So I got on the elevator with Deputy Piper. I went down. I called you out of the jury room, which I immediately caught a whiff of it. But man, when you and I got in the elevator together and those doors closed, I could taste it. The smell was so strong. You also are wearing your pants in a way where your underwear is showing, which is not appropriate for court, but I'm noting that as a side point. The marijuana is my main issue here. So here's the deal. You may provide testimony if you wish, but you're under no obligation to do so. As this is what's called a direct contempt hearing, it is me saying I saw this thing that disrupted the orderly operations of this court, because instead of calling this calendar and managing this, and instead of the clerk's office downstairs managing the jurors and getting everybody out the door, they were at a standstill because they were overwhelmed with the smell of marijuana downstairs. To which I know it came from you, because A, it doesn't smell like that anymore, is my understanding, and B, again, you and I rode the elevator up, and it was so strong I could taste it. Do you wish to provide any evidence in your defense, or do you wish to remain silent?
Silent.
Okay, good call. All right, well, in that case, I will ask you one last question, which will let me know which way I want to go. Do you admit or do you deny that you smell of burnt marijuana?
Deny.
Okay, it's 20 days to serve in the Spalding County Jail. You can take him downstairs and order will follow.
That way.
You may appeal this. You have 30 days and you have 6 months to use your habeas rights. All right, we're back off record while we're bringing new folks in. Okay. Um, y'all been busy. All right, so let's jump in. Y'all, I appreciate your patience today. Obviously, as you could tell, I was spinning a lot of plates, including disruptions down in the jury room and dozens and dozens of people waiting outside to get into the courtroom, or to the courthouse, excuse me. All right, so here we go. I'm going to go over this PowerPoint with you. This is the Spalding County State Court. My name is Josh Thacker. I'm your judge, and this is the bonded trial's final calendar call. I want to start out by saying that here in the Spalding County State Court, we believe that each of you, as you interact with this court, deserve the respect and the dignity that you would wish for someone you care about. We'll extend that to each and every one of you as we interact with you all here today. Hey, don't talk during court. You'll find out pretty quick that we are working very hard to try to return you back to your lives. You'll notice pretty quick, I don't have much patience with those disrupting those efforts. All right, nobody's virtual. All right, everybody grab your phone out of whatever pocket, purse, pouch you've put it in. Please shut it off at this point. If it rings after this moment, it slows everything down. I have to respond. I've already had one contempt hearing this morning. Please don't make me have a second. All right, this is the correct courtroom for you. If you're arrested on a misdemeanor here in Spalding County, you appear to waive your arraignment date. You then appear to calendar call. It says last week, but that would be in week 1, a couple weeks ago, and you requested a trial of some sort. If what I'm saying does not sound correct, show the bailiffs your paperwork, and they'll move you in the right direction. But it's my understanding everybody in here has gone through and checked in with the bailiffs already. This is what's called final calendar call. So this is where I go over your rights one last time. I talk through your options, and then you or your attorney give me final confirmation of what to do with your case. You may have a trial, and most of you have already selected either a bench trial or a jury trial. A jury trial is where 6 jurors issue a verdict on your case. And then a bench trial is where you give me permission to make the guilt or innocence decision without a jury present. At this final calendar call, you may also ask for a conference with the solicitor's office. They are under no obligation to meet with you. That's only if they are willing. You may ask me about an attorney, and we'll have that conversation. And then you may also choose, and this is a new option, it's called a non-negotiated plea. It's also known as a blind plea. It's a plea of guilty without a conference with the solicitor's office and without a recommendation. So a little bit more about a non-negotiated plea. It's if you are unsatisfied with the recommendation you have received from the state on resolving your case, but at the same time, you don't want to go to trial. If those two things are true, then you may want to consider a non-negotiated plea. A non-negotiated plea is where you admit guilt to the charge, and then I decide your sentence with no jury present. And whatever the court's decision is on that, it is final. All right, so that's a non-negotiated plea. If you're here for a jury trial and you realize that you no longer need a jury trial, bench trial is sufficient, you just let me know that when your name is called. I'll mark you as a bench trial. We'll have you sign a bench trial form, and we'll keep moving. I have no preference. I'm just giving that to you as an option. But you may not upgrade from a bench trial to a jury trial because we've already factored that into our plan this morning. If you are interested, if you're a veteran or you have a mental health diagnosis, I'll remind you one last time, if you are interested in getting your case dismissed, then if you're representing yourself, ask for a conference with a solicitor. And Ms. Cameron's not here this morning, but you can see if you are a candidate for our accountability court. If you have an attorney, simply speak with your attorneys. They'll fill you in on any questions you may have. The charges in this courtroom are all misdemeanors. The average misdemeanor carries a maximum punishment of 12 months to serve in the Spalding County Jail and or a $1,000 fine. A few minor traffic charges like seatbelt have a lower maximum fine, and a few high and aggravated misdemeanors have up to a $5,000 maximum fine. All right, you have the right to a speedy and public jury trial. That's where 6 citizens of Spalding County decide guilt or innocence on each of your charges. Again, you can choose a bench trial. That's where you give me permission to make the guilt or innocence decision without a jury. You may also waive your right to a trial and close your case with a plea. I have no preference. You must knowingly, voluntarily, and intelligently choose for yourself. You also have the right to be presumed innocent. You have the right to force the state to prove your guilt beyond a reasonable doubt. Cross-examine the state's witnesses. Subpoena your own witnesses and evidence to court. Testify or not testify to not incriminate yourself, and if you choose to remain silent, your silence cannot be held against you. You still have the right to have an attorney. You may hire your own if you so choose. However, if you did not ask in week 1 to apply with the Public Defender's Office, then you have very likely waived that right. But if you want to have that conversation again, we can. All right. An attorney would help you understand our criminal justice system, would explain what your charges are and what the defenses are to those charges, file motions on your behalf, engage in plea negotiations, subpoena witnesses and evidence for your defense, conduct a trial on your behalf, make objections, protect your record and appeal a conviction, and otherwise work to protect you. All right, first offender and conditional discharge. These each allow you to enter a guilty plea without being convicted. However, you only get one of each for your entire life. First offender is for everything except traffic-related charges, so no DUIs. And then conditional discharge is for drug-related offenses only. All right, no-low contender and traffic charges. We call this a no-low plea for short. It's where you enter a guilty plea without admitting guilt, and it is available on most basic traffic charges. You get one no-low every 5 years, and that is measured from the incident date to the incident date, the ticket date to the ticket date. The no-low will usually prevent points. It'll usually save your license. It won't help you much if you're under 21. All right, if you're here today and you're not a U.S. citizen, you need to know that any conviction will very likely have a negative impact on your immigration status. All right, family violence charges. Several of you are charged with family violence charges on this calendar. If that is you, and if you are convicted of those family violence charges, then you will lose your Georgia weapons carry permit. And federal law says that you may never again possess a firearm or ammunition. All right, habeas corpus. We call this habeas for short. This is a weird old law. And again, it's my job to explain it to you. And so here goes. If you're convicted of these charges, you may sue Spalding County civilly over in Superior Court to challenge your conviction. All traffic charges have a 6-month window to use your habeas rights. Everything else has a 12-month window to use your habeas rights. All right, you may conference today. You may ask for a conference today with the solicitor's office. That's out of respect for the jurors. And if you are asking for one, I'll remind you that the solicitor's office is under zero obligation to meet with you. They do represent the state of Georgia. They're not your attorney. If they do agree to speak with you and you do reach an agreement, you can resolve your case without a trial. If you do not reach an agreement, then you must sit and wait in the courtroom, and then I'll give you your next set of instructions. Some of you may receive probation today. If so, you'll be supervised by the Spalding County Sentence Enforcement Team. There's a one-time intake fee that actually is $50 per case, and then you can work off your fines at $10 per hour, and then each of the supervision fee is $60 each per month. All right, all the bench trials and jury trials are together in this trial calendar. Last week, it was week 1, that was your calendar for calendar call. This is week 2. All defendants must appear each day until your case is resolved, because I want you to watch the other trials so that you can learn the procedures that we're going to be following with your trial. We will be running 2 courtrooms this week. Judge Essery is here, and Ms. Donna is going to run a second courtroom as soon as we get that second courtroom cleaned up and cleared out. Your case will be reached for trial. All right, bench warrants have already been issued for a lot of names on this calendar and will be issued for folks who aren't here today that should be. If you recognize the name of anybody who is absent, call them, tell them to get down here, and you'll definitely save them a great deal of future trouble. I'll remind again that you were required to let me know if you had any motions, speedy trial demands, or anything else that I needed to factor into the trial of your case. If you did not get this information to me, and I did not preserve it in open court on the record, then they are waived at this point. All right, I'm about to call the calendar. When you hear your name called, stand up for me. If you're not able to stand up, that's okay. Wave your hand real high. I just need to know who I'm addressing out there. If you have an attorney, remain silent. Let your attorney announce for you. And then the announcements are, you're going to confirm if you want a jury trial or if you want to move to a bench trial, ask for a conference, an attorney, and then are there any motions? All right, anything, Piper?
You just have Mr. Ogletree back there.
Okay. So he's our jail case and he's our first up.
Yes.
And if we do need to try that, we do need to have a conversation outside of the jury's presence about the bandit and what court services needs from me. So,
That's Mr. Fuller's case.
yeah, so.
Yes, sure.
All right. All right. Any housekeeping before we jump in?
No, sir.
All right. Here we go. Bradley Abernathy. Susan Miller.
Ms. Miller's got a leave-in, so this case and her other 2.
Okay.
have
A
been
reset.
continued to
All right, reset. All right, and then Alexander Briante pled.
No, sir, Judge, that was scheduled to be a plea today.
Okay,
Miss Duvernay is Mr. Alexander's attorney. She has a emergency family medical leave in.
okay,
She sent last week, I don't know the specifics of it.
that's fine.
Your office said we would reschedule this to.
I agree. November. Okay, so reset to November 6th. All right.
I believe he's here, Judge.
Bronte Alexander, you can come on up. Your attorney had an emergency medical matter. Come on up. Let's have him sign a reset for that. You can come up to the podium. So, contrary to popular beliefs, attorneys do have lives outside of the practice of law.
Correct.
So sorry that you're here, but your attorney's had an emergency medical matter come up.
Okay.
And so I think it was late last night or sometime yesterday, I said we'd reset that and we'd have you sign a reset. So
Okay.
in just a moment, I'm gonna have you step out into the hallway. The bailiffs are gonna come out and have you sign a reset notice to be back here on the 6th of November. Is that correct? And everybody's nodding at me. Okay. Then any questions?
No, sir.
Okay. All right. Well, just be patient. Like I said, your attorney's going to be out for a couple of days, but we'll figure it all out. Okay.
All right. I greatly appreciate it. Thank
All right. If you'll head back that way, and you'll meet Clint out in the hallway. All right. Matthew Alexander is reset for Susan's leave. And that's page 1. All right. Page 2 is Abercrombie. That's also Susan Miller. So that's also reset. All right. And then we have Italian Ambles.
That's a bench trial, Judge.
Okay.
Or as soon as the.
Okay.
Clear down there.
Thank you much, Ms. Ambles. All right, and then we did Memory Argo as a pretrial.
That's correct.
And we finished it, I guess.
As far as I'm aware, yes.
Okay. Fernando Cannon was reset to November.
Okay. I didn't have anything on that one. 11-6.
Is Fernando Cannon here? Okay, I just have reset to the December trial calendar with calendar call on 11/18 is what I have. Frankly, I'm glad we moved that one to December. I mean, it's a suspended license, so. All right. Kendarius Cheeves.
That's Mr. Charles's case, Judge.
Okay,
Because of his medical issues, we moved all his, excuse me, we moved all of his cases off this calendar.
that's fine.
Sure.
Okay. Is Kendarius Cheeves present? Okay, we're good to
Miss
go.
Porter was here, I think. She's already.
I figured you'd gathered up all your people. Okay. Then I'm gonna mark that off. And Ms. Porter, is the Argo thing, I've already signed that, haven't I? Okay, so we're good to go. All right, I'm marking Argo off my list of things to worry about. All right, David Delasaria was a pre-trial, yeah. I remember that from the Thursday. All right, Duff was reset with Dutton to January. All right, Gilbert Duncan was Frank Hicks. Okay,
That's a sign up, please, Judge.
that sounds great. Excellent. All right, does he need to go sign up with probation? Does he
I
have,
don't believe he's met with probation.
he had a chance to meet with probation, has he? Clint, or Margaret, Mr. Duncan, if you'll head out those double doors, and if you want to head out that door as well, you're just gonna have a meet, he just needs to meet with sentence enforcement and get his paperwork signed up. He's already heading out. All right, Elliot pled. So that case is closed. All right, Samantha Elrod with Harry is reset. January 5th, got it. All right, so Harry's cases are moved. All right, Monica Evans. All right, there she is.
I think she'd announced trial on that, so we'll leave it on the trial count.
Was it a jury trial or a bench trial? Bench trial? Well, hold on, let me see what,
Yeah, she wrote a jury trial.
okay, that's fine. Thank you, Ms. Evans. Jury trial it is. All right, LaCondria Foster. I have that as already a bench trial. I mean, I'm sorry, bench warrant.
Yes, that's correct.
Okay. All right, so Foster's already a warrant. Over to you, Mr. Fuller. Callie Hambrick.
Yes, Ms. Hambrick is here, Your Honor, and that will be, I understand that Wayne Singleton will be ready on that one.
Okay,
Yeah, and that's out for trial tomorrow morning.
Okay. This sounds great. Kenneth Haynes.
That's a bench trial for today.
Okay.
So, yeah.
Haynes, wave at me somewhere. There we go. Okay, didn't stand up.
Well, I guess make sure.
All right, Camonte Haynes.
He's part of the same case, Judge.
Okay. Will they be tried together?
Yes. And there's a third one too.
Okay, so we'll try Kenneth Haynes with Camonte Haynes, and who is the third one?
Nakari
Johnson.
Okay. Okay, and Camonte Haynes, you're in the back, and then Nakari Johnson, where are you? Okay, he's over there. All right, all of those three are accounted for. All right,
Your Honor, Ms. Hambrick wants to know if she's excused until tomorrow.
let's have her stick around a little bit because I need to make certain there's a few more items on the record.
Thank you, sir.
Okay. All right, Ho is put on the 1096 calendar, and it's Harry's. We'll circle back. Charlene Horn. I have
I'm sorry.
in the hallway. Kids have confirmed flu.
That's what I was about to
Yeah.
announce. She's home for a bench trial today.
Okay.
I think it's the first calendar this one's been on.
Okay. I'll take a look at it and we'll see. So, all right. Haley Howard.
Judge, she played into accountability court with Jacob Kuttner
Okay.
on this case and the case on the top of the next page.
All right. So, Judge Estries, that one's heading your way. What if we, on this Horn one, you okay if we put it, do you have a preference where I put it? December or January?
You can put it on one of those, it's just a shoplifting, put it on one of those ticket.
Okay, so December.
December ticket.
So, all right, y'all can go ahead and as soon as you get that ready, she can sign it and go. So I'm gonna put reset December. All right, Hughley. Ms. Hughley?
Judge, I'm a little confused on that one. That's you scheduled that for a bond review last week?
Yeah, I got turned around that she was on this week's, but I did not release her from this week. I just said, you also need to be here.
Is she present?
No,
Okay. The state allows for a bond forfeiture and a bench warrant.
granted. All right, Jenkins. Is Robert Jenkins present? No response.
That was already a warrant, Judge.
Already a warrant. Got it. All right, Johnson is here. He's already waved at me from the back. He's a bench trial, and he'll get tried with the two Hayneses. Got it. Gladys Jones is Harry's, so it's reset.
That one was actually already continued,
It was, okay.
both cases.
And as well as April King, same thing?
No, sir, Judge. Ms. King pled into accountability court.
Okay.
On the 25th or the 26th. She is scheduled for October 2nd for the check-in on that.
Okay.
Our understanding is that Ms. King does not want to do accountability court. She's asking to withdraw her plea. I figure we can just handle that on October 2nd.
Yes, that sounds great. Ms.
But
King,
we were not looking for her today. She'd already pledged, so I don't.
yeah. Ms. King? Okay, just being careful. All right, that sounds great. I'll review that, and if she wants to see about withdrawing her plea, she needs to file a motion. All right, Kimberly Berry, no, I'm so sorry, Renee Mallard with Kimberly Berry.
Miss Berry is out on maternity leave.
That's right. Did we ever get pictures of the baby so we could tell her how cute the baby is? Maternity leave. Got it. Okay. Reset. Got it. That's a good reason to be out. Okay, Brandy Mangum? Mangum? No?
That's on for a bench trial today, Judge.
State of emotion?
Yes, we'll ask for bond forfeiture and bench warrant.
Granted.
Was here.
What? Brandy Ishanda Mangum.
Let me see if she's in home.
Okay.
Check in.
Mangum?
Well, I'll leave it as it is.
She's here too.
Okay.
She's puny.
So,
She's
okay.
just sitting outside.
Oh, okay.
You can put her in.
All right, leave her out there then. It's not a warrant. Sick. All right. Shaquila Marshall's pretrial diversion. Have it as resolved already.
That's correct.
Martin is an accountability court plea.
That is correct.
Done. Tarika Martin, I have as Harry's, so it's been reset. Okay. Tarika Martin? Oh, she's here. Okay. All right. So you're going to talk to Ms. Porter and she'll give you your next set of instructions. Okay. All right. Thank you very much. Oh, you can just grab a seat. She'll come see you in a minute. I'm going to finish calling the calendar first. Okay. All right. Lisa Mayfield, I show as reset. Also Harry's.
Yes, that's correct.
And then Rashad McMullins pled.
Yes, sir.
Is Kenneth Meeks present? Kenneth Meeks?
He was a warrant already on both of these cases, I believe.
Okay.
I think there's two. Is that right? Okay.
Okay,
This is
so-
the only one that was on the calendar.
Okay, this will control, so that'll work. All right, that's page 9. Timothy Mortimer, he pled,
That is two plea on 10-2.
oh, 2 plea. Got it.
I don't remember why but he's waived his.
He needed something. I only remember Derek coming through and saying, can we have just a little bit of time for him to get blah. That's it. So
I know he waived.
I've
his-
literally just expended all knowledge I have on the subject. So, and, okay, that'll work. Okay, that's page 10. Ogletree is here. He's back in the back. He's our first up
Yes.
for trial. All right, our Ardashia Parks pled, I believe.
Yes. That's what I'm showing.
All right, Sanborn Phillips,
Oh, jury.
jury trial.
Judge, he's actually waived his right to a jury trial.
He's already done a bench trial?
He's had a bench trial waiver.
Okay.
The state's gonna have to continue that. We have a witness that's out of state.
Okay,
First time it's been on the calendar.
okay. Mr. Phillips, hold on just a minute. I'm gonna have a little more of a conversation with you about that. Angel Rogers, I shows a pretrial diversion with Harry. Daryl Seeley, I shows reset.
That will continue.
Okay, Aaron Shackelford, I show as closed already with a pretrial diversion. Jonathan Starks. Okay, is that a jury? I see you there, thank you. That column. Is that a jury trial or bench trial, or do you remember?
I think he was on for a jury trial, if I recall,
Okay.
but I'll be glad. We have the witnesses here.
Okay,
I'll be glad to speak with him. I think he's just at conference.
okay.
I'll speak with him in just a moment.
All right, Troy Trotman, it's pretrial with James Dutton. Aviana Tyus,
Yeah,
she's already reset. Okay. All right, so I'm marking that off my list. All right, Jose Vasquez, that shows a bench warrant. Vasquez? No.
That was already a warrant?
Yep. Okay, James Walker. All right. Is that a jury trial or?
Yeah, I think those are on jury trial, Walker, and then the next one, Watkins. They're
Okay.
Sure, those are two more continues in here.
Okay.
All right, and then Williams.
She was reset.
Excellent. Great job. All right, Carl on Douglas Willock.
Yes, Your Honor, we have, worked that out, so we're ready to take the plea on that whenever the court's ready.
Okay.
I've got the plea paperwork. I guess he needs to meet with
Okay.
probation.
Mr. Willock, if you'll step out into the hallway, Sense Enforcement's gonna fill out some paperwork with you, and then I'll take your plea. All right, that's Mr. Willock. Is there anyone here who was a witness who was subpoenaed to be here today? If so, just raise your hand. All right, 1, 2, y'all can take your hands down. All right, y'all will talk to the solicitor's office in just a minute. They'll give you instructions. It's these folks in the very front corner.
Yeah, they're both on Mr. Stark's case.
Okay. All right, now, is there anyone else whose name was not called? Stand up for me. Is there anyone else whose name was not called? All right, we're in good shape then. All right, so here's what we're gonna do next. I've got a couple of pleas that need to be taken. Looks like a couple more conferences need to be completed. I need to talk to, let's see. Actually, we're in pretty good shape. Okay. Frank, we can take your plea whenever you're ready.
Monica Evans.
Mangum. I'm gonna reset Mangum, the sick person in the hallway. Never been reset before. So, all right, so I'm gonna put reset. Did you get that, Kathy? Yes, sir. Okay, all right, you ready?
Yes, Your Honor.
You ready?
Yes, sir.
All right, grab that mic, confidently pull it up. It's for short folks like me and tall folks like you. All right, raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down, state your full name for me.
It's Gilbert Ian Duncan.
All right, Mr. Duncan, you're here on 24 SR 0841, and according to my calendar, you were on time for court today. Is that correct?
Yes, sir.
All right, and did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
All right, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after you had all the time that you needed to review it?
Yes, sir.
Did you have an opportunity to ask your attorney any questions that you had?
Yes, sir.
And did you understand everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job Mr. Hicks has done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
All right. Do you have any questions for me about anything before I speak with your attorney for a minute?
No, sir.
All right. Mr. Hicks, do you stipulate that there's factual basis to support this reckless driving charge from 12/14/23 here in Spalding County?
Yes, Your Honor.
And do you wish to enter a guilty plea, sir, to that reckless driving charge?
Yes, sir.
And then moving on to the speeding, 86 and a 55. Do you stipulate to the factual basis on that as well?
Yes, Your Honor.
And do you wish to enter a guilty plea on that charge?
Yes, sir.
All right, I find that between the attorney's stipulations as the factual bases combined with the defendant's request to enter guilty pleas, that there's enough for me to take these pleas. I find that Mr. Duncan is knowingly, voluntarily, and intelligently waiving his rights and entering this plea. I've reviewed the recommendation and I will follow it. Floor is yours if you want it. Anything you want to add?
We simply ask that you accept this negotiated agreement, Your Honor.
All right, which I'm happy to do. Do you have any questions for me, Mr. Duncan, about anything before I sentence?
No, sir.
All right, and following the recommendation that your attorney negotiated, the sentence of the court is as follows. 24 SR 0841, count 1, reckless driving, guilty, 12 months, $1,244. Count 2, speeding, 86 and a 55, guilty, 12 months, consecutive, $750 is your fine. That's 24 months of total probation. All other charges are dismissed. No alcohol, no illegal drugs, no hemp products should be tested for those. You waive any foundations for admissibility. You may go to e-report upon proof of out-of-state residency. Where do you live?
California.
Okay, that's a long way away. So my brother lives there, in Los Angeles, or lived there in Los Angeles for a while. All right, your case will close the moment you've satisfied your obligations to the court.
Yes, sir.
You must complete 40 hours of community service work as well as a DUI school. Now, the DUI school, have you already completed it?
No, sir.
Okay, a little trick. Go to DDS's website. There's a calculator or a converter, excuse me, and you go, I am in, and then you tell it what state I need to complete, and then you tell it the course, and then it'll say, in California, complete this course. That's equivalent to the Georgia DUI school course. Does that help?
Yes, sir. I just need to write it down.
Sure, that's okay. So you'll go to the Georgia Department of Driver Services website. It's kind of buried in there. You'll have to hunt around a little bit, but it'll help you complete the California version of Georgia's DUI school.
Okay.
It's a really nice little tool. I wish they didn't bury it. So, all right, you have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Do you have any questions for me at all?
No, sir.
Anything else? All right, you're released. Good luck to you, sir.
Thank you, sir.
And have a safe drive back.
Thank you, Your Honor.
All right, that takes care of that one.
Your Honor.
Yes.
I'm sorry, I just want to make sure I have the right one. Brandy Magna, you reset that one because she's ill? Is that the one you just asked?
Yes, I
about?
confirmed. Yes, I confirmed that it had not been reset previously.
Okay, I just wanted to.
And so you all may release your witnesses on that and just tell them that the court released them over your objection. So. I believe you've already signed a bench trial form.
No, I never signed a bench trial form.
Okay, well, let's figure that out then. That's why I brought you up, so we could have this conversation and figure that out.
Well, while we're here, I would like to ask you to go ahead and get this dismissed because under the state, Georgia state rule, it's been over 2 years. So, you know what I mean, statute of limitations.
Let me
Which the time I've been charged, time the prosecutor had ample enough time to prosecute.
Okay.
We're doing, in a duration of 3 years and a month.
All right,
Okay.
so you're doing a verbal motion for me to dismiss this case due to a statute of limitations.
Right.
Okay, perfect.
So Judge, this case, the incident date on this is August 22nd of 2020, August 21st of 2022. The accusation was filed September 8th of 2023.
Okay.
Your Honor, this involves an accident.
Oh, okay. All right, so let me, I'm
And
gonna
also,
deal.
excuse me, I didn't mean to cut you off.
That's all right. Let me just do my to-do. So my to-do list so far is, I'm gonna deal with the verbal motion, for dismissal due to statute of limitations violation, and I'm gonna deal with the jury trial. Those are the two things on my list so far.
Okay.
All right, go ahead.
All right, there was no felony DUI, so which is a statute of Georgia, 4 years of statute of limitation. So this is only a misdemeanor.
I agree with that, because I'm only a misdemeanor judge. So,
There you go.
I spent my entire career with felonies, and I love my job. So I am so happy to not be doing felonies. So if you had a felony and you were looking at me, one of us is in the wrong seat. So, all right, so let's deal with that. So the first question was, did the state file it? And the rule is that the accusation must be filed within 2 years of the date of the incident. So I'm looking at the date, the incident date is 8/21/22. So grab that, I'll tell you exactly where we're at. Grabbing my calculator. So 8/21/2022, and then the date that the accusation was filed was on 9/8/23. 9/08/2023. Okay, so it was the accusation was filed 383 days after, or 1 year and 18 days. So the statute of limitations defense does not apply because it was filed within the 2 years from the date of the incident to the filing with the clerk of this court. So as far as your verbal motion to dismiss for statute of limitations violation, I'm going to mark that as denied. So statute of limitations motion denied. Secondly, I show here that you and I have already talked back on August 26th of 2025 that I reviewed the bench trial form with you and that you requested a bench trial. James, if you'll show that to him. If you'll please look at that document and tell me if you recognize your signature.
Yeah, but that's why I'm telling. I stated jury trial.
Okay, let's look that up. All right, you'll pass that back, unless you want to look at it some more.
No.
All right, so this would have been on August 26th. I don't think I was the judge on that day.
I believe Judge Howell was here that day, Judge.
Okay. Well, then I was looking for my calendar with my memory of it, but I have neither. So I'll tell you what we'll do. The state's asked for a reset. I don't show that it's been reset before. Is that correct, Mr. Shepherd?
Right.
I don't know if Mr. Phillips has requested one.
No, I
I'm
never.
so sorry. The state's reset.
Yeah, I never requested one.
Okay. Then here's what I'm gonna do. I'm gonna reset this. Let's not get it too far away because I've got other stuff. Let's stick it on December, but that's just really for me to look at this question because we'll need to get, I don't know who the court reporter was that day. Yeah, and so I've got a little bit of homework to do. I was not the judge on the bench that day, so my calendar isn't helpful. And I don't remember if Miss Kathy was there that day or not. So we're going to need to do a little bit of homework when we're not sitting here in the courtroom.
Right.
I'm going to put you on the December trial calendar, not because we're going to definitely try it there, but because I want to go ahead and deal with this issue so that we know whether or not it's a confirmed bench trial or whether it needs to be moved to a jury trial. So just so you know, if we're not able to get it reset in time to get it there, I may need to move it to January. Just be patient with me, okay? All right. Do you have any questions for me?
No, I know.
All right. I tell you what, I'm going to, we don't normally file these, but because this is at issue, I'm going to file and ask the clerk to stamp up here, and then that'll leave this part. And then when we do the second part, we'll stamp there. And if you'll just if you'll just stamp that at the top, since it's at issue, and we'll just stamp it in twice, once for the top, once for the bottom. Okay. So we need to figure out who was so it was Judge Howell. And we need to figure out who is the court reporter. And it was from August 25th? August 25th. So who's the court reporter?
26.
26th?
The 26th was that Tuesday when Judge Howell was here,
Okay.
I believe.
Well, that's why we need to sort it all out. So, because the paperwork said 8:26, but the docket says 8:25, so we'll figure it out. Okay. All right. You got a reset for him?
Yeah, no, Margaret.
All right. If you'll step back that way over to Miss Margaret, she's going to give you your reset to sign.
Okay.
And when you come back on your next calendar date, we will address your bench trial versus jury trial question, and I'll make a final decision on that.
All right, thank you.
All right. Thank you so much. All right. Good stuff you got.
Yes, I do.
All right, take your hand down. State your full name for me.
Douglas Willock.
Mr. Willock, you were here on 23 SR 1070, and looks like we're going to do a dismissal or null pros on 25 SR 328. Is that correct, Mr. Touchdown?
That's correct, Your Honor.
All right. All right. Mr. Willock, you were here on time for court today. Is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, I did.
Did you understand those rights?
Yes.
Any questions I can answer for you about any of those rights?
No.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, I do.
Do you recognize it as the written version of those rights I read out earlier?
Yes.
Are these your initials next to each of the lines on page 1,
Yes, they are.
page 2?
Yes.
And is that your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, I did.
And did you understand everything that's on it?
Yes.
Did you have an opportunity to ask your attorney any questions that you had about this document?
Yes, I did.
Did you have all the time that you needed to speak with your attorney about all aspects of all of your cases?
Yes.
Are you satisfied with the job Mr. Touchstone's done on your behalf?
Yes, I have.
Do you understand that you have the right to a jury trial on your cases?
Yes.
And that by entering this plea, there will be no trials and both of your cases will be closed?
Yes.
Is that what you want to do?
Yes.
Okay. Do you have any questions for me about anything before I pivot to your attorney?
No.
Mr. Touchstone, we're going to enter pleas to counts 5 and 6. Is that correct?
That's correct, Your Honor.
And they're both obstruction charges?
Correct.
And do you stipulate that both of these obstruction charges are supported by a factual basis from 6/25/23 here in Spalding County?
Yes, Your Honor.
Okay, and Mr. Willock, do you wish to enter guilty pleas to count 5, which is obstruction, as well as count 6, which is also an obstruction charge?
Yes, I do.
All right. I find that between Mr. Touchstone's stipulations as the factual basis, combined with Mr. Willock's request to enter guilty pleas to these 2 obstruction charges, which again are counts 5 and 6, that there's enough for me to take your plea. I find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I've reviewed the recommendation, and I will follow it. Mr. Touchstone, the floor is yours if you wish to add anything.
No, Judge, we just ask the court to accept the terms of the negotiated plea.
Okay. And Mr. Willock, do you have any questions for me about anything before I sentence?
I don't.
Okay, you good? All right. Mr. Willock, the sentence of the court then is as follows. Count 5, obstruction of a law enforcement officer. Guilty, 12 months, $590 is your fine. Count 6, obstruction of a law enforcement officer. Guilty, 12 months consecutive, $590 is your fine. All other charges are dismissed. That's a total of 12 months probation. No alcohol, illegal drugs, or hemp products should be tested for those. You'll waive any foundations for admissibility. $50 intake fee, $60 per month supervision fee. Your case will close once 12 months have passed, no violations have occurred, and all conditions have been met. 20 hours of community service work will need to be completed at no less than 6 hours per week. You have 2 different no contact provisions. You have a no contact at all with Kamaya Jennings, and then you have a no violent contact with a Tanisha Rolick and a Casion Hart Willock. Are those names familiar to you? Okay. I just want to make sure I had them right. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Mr. Touchstone, anything else?
No, Your Honor, that's it.
All right, I've already signed the dismissal. Mr. Willock, do you have any questions for me?
No, Your Honor.
Okay, then I'm going to pass you off to Mr. Richards. He's going to walk out several doors. Oh, yeah, let me sign. Yeah, let me sign. All right.
Okay. All right, Judge, that concludes my business. May I be excused?
Great to see you as
All
always.
right, good to see you too. Appreciate it.
I've protected you from whoever's hunting you for as long as I can. I'm sure somebody somewhere is looking for you. Okay. And are y'all about ready for me to let Judge Essery take over with go set up for the bench trials down there?
Yes, sir. I mean, all the witnesses, we didn't have a courtroom until after lunch, so all
No.
the witnesses were lined up for them.
Oh, for after, okay.
Lined up for after lunch.
Okay, perfect. All right, so Judge Essery. Check it out, make sure it's ready. Yeah, so if y'all kick the proverbial tires and then at 1:30 you'll have, I'll send the rest of these defendants down with you. All right, let's make certain we have a definitive list of those that need to return at 1:30 with Judge Essery. Stand up as I call your name, and somebody correct me if I call the wrong name. Here we go. I have Italian Ambles, please stand. I have Kenneth Haynes.
That's correct.
Perfect. He's got his hand up. Camonte Haynes in the back. All right. Those who can stand, please stand. Nakari Johnson. Okay, I show those as the bench trials that have remained after continuances and attorneys and whatnot.
What did we do with Ms. Horns, the one with the,
I reset that one to December.
and then the other one that I was showing was Mangum? She was out in the
Yes,
hallway?
she's out in the hallway with a sick kid, never had a reset. I moved it to, I think, December. You know where you put that?
That was moved to the next one to this one.
That's fine, I don't have a preference. Just want to make certain my notes are correct. So move to January. March. Okay. Okay. So that's everybody. All right, to the bench trial folks, you all It's 10:45. You all are to return at 1:15. Yes, ma'am.
I was trying to see, cause I didn't have my witnesses come. What should I do?
Okay.
I have to continue, so reset.
I'll need to check the file. Just grab a seat.
Okay.
Okay. You three. Yes, sir. Well, now we have to have those conversations. All right, everybody sit back down. That failed. All right. Well, then let's do this. Do we need to have any housekeeping we need to do with yours?
Ms. Henry,
On anything that you have that we need to address?
Your Honor, on Overtree, I have a motion in limine that I'd like to call the court extension, but that's it.
Okay.
And on Ms. Hamrick, I understood it was out, will be out tomorrow.
Okay.
That's correct.
Again, and she's still waiting before she can be excused.
Okay.
Okay.
I mean, I usually have folks who are here watch trials, so I don't know that I'm willing to grant that because she's got you here in your seat about to work your magic. And I think she needs to watch you in your seat working your magic. So the fact is that I'm not inclined to let her go.
All right, Your Honor.
Because I think this is the best use of her time is to be here and learn and watch and see how this works. So, all right. So Ms. Hamrick, I'm sorry about that, but the request is denied. So, all right. So let me start talking to these folks that I thought I was about to tell them to come back at 1:30. All right. Let's start with, Ms. Ambles. Ms. Ambles, come on up to the podium. All right. Raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down. State your full name for me.
Italian Latrice Ambles.
All right. Ms. Ambles, you are here on 24 SR 1234. And according to my calendar and my memory, you're on time for court today. Is that correct?
Yes, sir.
And when I just started to send you downstairs, to release you to come back after lunch for your bench trial, you stated something that needed my attention. What was that?
I have the person that was actually in the car with me. She hasn't came yet, and I need her here.
Okay. Have you served her with a subpoena?
I can't because I'm representing myself, so I asked, and she said she was coming, but she's not here.
Okay. So, y'all have blanks down there, don't you, for subpoenas? Yeah. So the clerk's office has a blank stack of subpoenas downstairs. So I'm going to gently but firmly push back on that you can't, this idea that you can't subpoena people. Because the clerk's office literally has blank subpoenas downstairs where you go down there and you fill out, I want so-and-so here. And then they stamp it. And then you have that served on that person. I'm saying your request for continuance is not proper because the way this works is if you serve somebody with a subpoena, I can see it here because somebody's filed something says this person is under subpoena. And I'm going to give you an absurd example of what I'm actually looking at. You might as well be saying to me, hey, I'm waiting for the President of the United States to get here because that's my witness. Right. And I'm going to look and I'm going to say, well, the President is not subpoenaed. So I'm not going to wait on the President. You see how this works. Yes. So can you get this person here at 1:30?
I'll try.
That's going to be what you're going to need to do. Because again, I can give you what you need if what is in the file matches what you're saying. In fact, I'm legally obligated to give you what you need if what you're saying, and I would do it anyway, but it's not here. I'm not seeing it.
Okay.
So I am going to release you until 1:30. Your case is moving forward. I will say that your case has been pending now for, close to 400 something days, 458 days, according to my calendar. And we had We had an arraignment back in May, so we've
Right.
known these dates since May. You signed for them, and we had calendar call back on the 25th of August,
Mm-hmm.
and then we're here today. So, all right, so you need to go call your folks and tell them you need them here.
Okay, so
And then when you come back at 1:30, as soon as you come in the door, take a right. There's a little service elevator there.
okay.
The deputies can point you that way, and you're going to go downstairs to that little makeshift courtroom for bench trials.
Okay, and then one more question. I'm
Sure.
sorry.
No, it's okay.
The officer, would he also be here to write?
The short answer is I don't know. The
Oh, you
longer
don't know.
answer is I would imagine.
Okay.
So, but that's just me saying I don't know. So,
Okay.
all right. Anything else?
No, you've been great. Thank
All
you.
right. Thank you very much. We'll see you at 1:15. Be backing downstairs into the grand jury room.
Thank you.
All right. Thank you. All right. Haynes, and Johnson, come on up. Ken, I'm gonna sit at the table just for a second. So I got 3 folks coming up. I want one of you at the lectern. We're gonna let one of you be seated.
Your Honor,
Yes.
you probably want the 2 Haynes together on the first.
Are they trying them separately?
We're gonna try them.
Okay. Okay, the Hayneses, grab a seat. You're Mr. Johnson? All right, y'all can go grab a seat out there yet. They're telling me, hold on just a second. Let me talk to Mr. Johnson separately. All right, raise your right hand. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. Mr. Johnson, I was about to release you and tell you to be back at 1:15 for your bench trial, and you said something out there that made me have to pause. What was it?
I needed to speak to an attorney. I was asking if I could get like counsel appointed.
Okay. So this is 23 SR 1006. All right, so I show your incident date as May 26th of 2023. Does that sound correct?
Yes, sir.
All right, that means that your case, according to my calculator, has been pending for 850 days. What actions have you taken in 850 days to secure the public defender's office?
I would say I end up calling the public defender office and trying to get in touch with them. I wasn't able to speak. I spoke to a solicitor
Okay.
about the case. That was like the only person I reached out to as far as like regarding the case.
Okay,
Mhm.
so it looks like we had your arraignment date back on April 14th of 2025. Does that sound correct?
Yes, sir.
And then I'm going to push this up to the screen here so we can look at this together. All right, is that your name?
Yes, sir. That's it.
Is that your signature?
Correct. Yep.
Those are your initials?
Mm-hmm.
And you see where it was dated April 14th of 2025?
Yes, sir.
That's your contact information?
Yes, sir.
Okay. And you see where it says, "It is my responsibility to hire an attorney or apply with the public defender ASAP. The public defender's office is located at 435 South Hill Street, Griffin, Georgia, 30224. Their phone number is 678-688-8296. Is that correct?
Correct.
All right, so you were given that information on April 14th?
Yes, sir. But I think I got that one copy. I think I signed that here. I didn't receive a copy on my own.
No, I told you you wouldn't have received it on your own. We do everything here in the courtroom.
Got you. Okay.
So, all right, well then let's hop over to, we came back on calendar call date, which would have then been, August 25th, is that correct?
Correct.
And on August 25th, I don't believe I was the judge on that one, but you would have been given the opportunity to apply with the public defender's office. I would imagine they were here in the courtroom.
Mhm.
Did you talk to them on that date?
I think I spoke with a solicitor. I think I spoke.
No, the public defender's office. Look, you're looking to your left. I want you to look to your right. That's where the public defender's office would have sat, the table on your right.
I'm not sure, no, sir. I think the last calendar call I came late, so I wasn't able to speak to an attorney or a public defender.
Okay. Did you speak with anybody between August 25th and today?
No, sir, I haven't.
All right, is there anything else you want me to know about your request for continuance so that you may go apply with the public defender's office?
No, sir.
All right, that's denied. You've taken no substantive action between here and there. I mean, like, if you'd given me something to work with, I could have worked with you, but you've given me nothing.
Yes, sir. The only thing I know it's been like.
Go ahead. If you want to put anything else on the record, go ahead.
It's been like 3 years since the case has taken place, so I was like, I mean, I moved away, so it's like I wasn't,
Do what?
like I was saying, like I ended up moving away, and I wasn't like, like actually in contact with the public defender's office or anything like that. And it's been so far since like the incident took place, I haven't had enough time still.
Okay. Anything else you want to put on the record before we move to the next topic?
No, sir, that's it.
Okay. All right. I've already made my ruling. All right. So, so your request for that is denied. I'm gonna go ahead and lump in that you asked for more time so that you could subpoena witnesses, and that's also denied because while you were frankly not taking any action to get an attorney, it's clear to me from the record that you've also not taken any action to properly secure witnesses for attendance. So if you can get them here today at 1:15, that's great. But if not, I'm frankly not very sympathetic because you've had 800 and something days, 850 days to subpoena witnesses and have them here.
Gotcha.
So that request for continuance is denied as well. Anything else?
No, sir, that's it.
All right, I'll see you. So at 1:15, you're going to come back here. You're going to go down the service elevator, down to the grand jury room, and Judge Essery is going to be here to try your case.
Okay,
All
gotcha.
right, thank you. You're free to go. All right, the Haynes can come on up. All right, you are Camonte Haynes?
Yes, sir.
All right. Do you need to talk to me about anything before I release you until 1:15?
No, not really.
Okay. Thank you. Mr. Kenneth Haynes, do you need to speak with me about anything before I release you until 1:15?
No, sir.
All right. Both of you all are free to go until 1:15. Come back here, go down the service elevator into the grand jury room. That will be your courtroom this afternoon for your bench trial. Okay, now we got the bench trials back on track. Do they need to head out separately or something? That's fine. Okay. Okay, y'all keep walking, please. Okay, you said Monica was an all pros?
Yes.
Okay, marking that off my list. All right, so I just have the trial that's set up tomorrow morning with Ken. That's Miss Hambrick. She's gonna stay, she's gonna watch the other trial. I have the bench trial folks are all with Judge Essery now.
That leaves Walker and Watkins. That y'all, Walker Watkins?
All right, you two come up to the table here.
And Judge, I gotta look at a couple things on that one real quick.
Okay, I'm just gonna talk to them for a minute. And then we'll cut them loose until, Ms. Hambrick, your attorney's about to do some motions, which is why I've got you still sitting here. So I just want you to know that your attorney is about to do something official, which is why I'm asking you to stick around. All right, this is Walker and Watkins. You're James Frederick Walker III,
Yes, sir.
and you're Jennifer Marie Watkins.
Yes, sir.
Both of y'all raise your right hands. You solemnly swear or affirm that any testimony you're going to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Yes, sir.
All right, you're both sworn. All right, so both of you have requested jury trials. And is that correct? We'll just do it this way. So we'll start with Ms. Watkins.
Yes, sir.
Yes, sir.
And both of you all are choosing to represent yourself. Is that correct?
Yes, sir.
Yes, sir.
Is that your free and voluntary decision to choose to represent yourself?
Yes, sir.
Yes, sir.
Anyone forced you in any way to represent yourself here in this courtroom?
No, sir.
No, sir.
Okay. All right, so you all are going to be staying with me until we get to your case because I want you to watch what's going on. I want you to see the other trials, and I want you to be thinking of any questions that you may have about the trial procedure and how things work and how things move. So I just want to make certain that you all know that you are not free to go, that you need to be in your seat at all times except when I'm adjourning court, okay?
Yes, sir.
All right. Do y'all have any questions for me about anything, no matter how minor, before I pivot to the other cases for you to watch?
No, sir.
No, sir.
All right. You all may move back out into the gallery. And you're welcome to sit in a more comfortable seat if you want, because y'all are going to be here a while. So, all right, Mr. Shepherd, anything else? I know you got to look at that, but I just
Yeah,
want
I'll
to get
take
that
a look
covered.
there.
Is there anyone I missed that I've not spoken with? You're Mr. Fuller's and Singleton's. Your community service work, right? Excellent. All right, well then, it's 11 o'clock. I'm just going to take a quick break, let Mr. Fuller get set, and then let Mr. Ogletree come on out. And then we'll just put a lot of stuff on the record, such as the motions in limine. We need to discuss bandit usage, and everything else. So, all right, we're in a quick break, and then we'll get started. 15-minute break, everybody.